So hello, thank you for joining us and watching this today. My name is Victoria. I am one of the estate planning attorneys with the Copenbarger law firm. We are doing this today in conjunction with Mr. Charles Sosa of Lifestyle Financial. The reason that we do this is we understand whether you're a client or not. When we start talking about estate planning, a lot of what we're talking about is finances and your assets and what kind of a legacy do you want to leave. So that means not only do we need to ensure you are protected on the estate planning side, we also need to ensure that you have the correct tools through other professionals from a financial side, because it does often carry on beyond what we are doing here at Copenbarger. So if you are a client and you have not met with Lifestyle Financial, I definitely encourage you to do so. If you're not a client yet, welcome. We're looking forward to getting to know you and for you to get to know both of us. I really do want to focus on the legacy component and specifically the Secure Act. One of the big things I know many people have been told over the last couple decades is how important it is to be saving into different retirement plans, IRAs, 401ks, things of that nature. But with changing laws, there can be change in strategy, there can be change in what you need to be aware of, both pros and cons of legal changes, but that definitely ties into your estate plan. There are pieces of your estate plan that even though certain laws may more directly impact your financial plan or assets specifically, your estate plan does have a role to play and needs to be kept up to date as well. So first and foremost, for those of you either who don't know us or who haven't seen us in a little bit, I want to make sure we either introduce you or reintroduce you to our team of attorneys. So we have one of the largest team of estate planning and estate-focused attorney groups in the state of California. But we also go beyond the estate planning side of things. So while yes, today is a lot of the foundational, what do you need to have set up, there's other components that will at some point or another come into effect. One of those times in life is after somebody passes away, whether it's you directly or a loved one that you know who passes away. That is where our estate administration department comes into effect. They are there to ensure that after someone passes, the loved one or whomever is in charge of going forward and actually settling everything, we're able then with administration to walk alongside them and help either take most of the legal and necessary tasks and do them ourselves, or we at a minimum can act as a guidance and an advisory role. We also have a business and tax department. So for those of you who do have estates where you're concerned about taxes, if you are in a position where you have your own business, you're involved as an owner in a business, or in some way, shape, or form have business questions, we can also answer those in-house for you as well. And then most of what we focus on at Copenbarger is how to avoid the court. We want to make sure that after you pass, during your life, whatever phase we're in, you or your family are not stuck unnecessarily in court. But unfortunately, things happen. After somebody passes away, there's the two, frankly, almost most powerful feelings that then go into effect, and that is grief and greed. And when those things combine, it unfortunately can lead to a necessity of court, regardless of what planning had been done before you passed away. So we do have our estate litigation department there to walk alongside you or those people who are left cleaning everything up to make sure that they are absolutely represented to the best of the abilities and can make sure that they and your estate have protection from any predator who would otherwise seek to harm the estate or the loved ones left behind. But as attorneys, we could not do what we do without our incredible staff. And so we have a staff of about 35 to 40 people any given time, and they are the reason that we are able to help people in such a timely and efficient manner and continue to serve our clients as best as we are absolutely able to. We also have offices all over the state. And so if you have moved, if you have family in a different location, odds are we still have a physical location close by. If not, we can do appointments on Zoom, the phone. There's different ways that we can still make sure that you are helped and protected, even if you're not physically located by one of our offices. All right, so let's get started. So one of the big things to focus on when we're talking about the Secure Act, which I'll go into more in just a moment, is your legacy. Legacy is really looking at, after you are gone, what has been done to make sure that whatever you've left, whatever your intentions are, that those really are carried out to the fullest. Whether that's focusing just on the assets, the emotional side of things, religion, morals and values, legacy has a lot to do with your estate planning. Today, we're really going to focus on the asset protection part of things and ensuring that going forward, no outside predator can reach those inheritance assets unless you've allowed it. So first and foremost, legacy starts with you. And that means, do you have the proper protections, not only for when you're gone, but also for when you are alive? So on your checklist, you want to make sure you have a healthcare directive, a durable power of attorney, a living trust, and a will. So first and foremost, anybody over the age of 18 needs an advanced healthcare directive. So this is your medical power of attorney. This is also, though, a document that needs to have been done after 2004. So if you have a healthcare directive in your possession, but the date on it was prior to 2004, it is actually no longer valid. The reason this is such an essential document to have is that nobody has an automatic authority to act on your behalf medically unless you have given verbal permission or it's in writing. So what that means is, even a spouse, if you can no longer verbally tell a doctor that your spouse can be your advocate, if they do not have it in writing, legally the doctor cannot tell them anything about your care. They also are not able to then have the spouse make decisions for you. This is the same for children, for your parents, whatever role you're in. Regardless of relationship, unless you have verbal or written permission, you have no right to make decisions on behalf of someone else medically. The other thing that goes into these healthcare directives are certain decisions that you can make ahead of time. In our documents, that includes organ donation and life support. These are decisions that are extremely stressful, frankly, for whoever needs to make them if they don't have guidance. When you get to the end of your life, it's still going to be very likely emotional for at least a handful of people. And some of that emotion comes from them now having to make decisions for you that you can no longer communicate. But if you have put it into effect ahead of time, if you have said, yes, I will give organs, no, I don't want life support if I'm not going to recover at this point, taking the weight off of those people's shoulders can be a gift that, speaking from personal experience, is unquantifiable. It allows them to know that they're carrying out your wishes and allows them to focus on the grieving side of things rather than waffling and waning, rather than feeling guilty about the decisions that they now need to make. Now, the question is then, who makes the decisions? So in your healthcare directive, you name who makes those decisions. So you get to decide, my spouse would be the person, my children would be the backups, my friend would be the backup, whoever it may be, you get to determine that, but it has to be written down. Otherwise, again, no one has automatic rights to do so. The next document that you need if you're over 18 is a durable or financial power of attorney. So this is dealing with the money. This is saying you are in a position of incapacity, whether temporarily or permanently, and you can no longer manage finances in that time frame. So again, no one has an automatic right. Now, there's a little bit more flexibility here for spouses on certain accounts, but in general, no one has an automatic authority to just go in and start accessing your money, even if it is to take care of you, which is a very good thing. One of the questions we often hear on this document is, well, if my spouse is a co-owner, co-signer, why do I need this? This is where it gets to, which assets do you have? Because on accounts like your retirement, your spouse is not a co-owner, they are likely a beneficiary. Well, a beneficiary, spouse or otherwise, has no automatic right to go and manage that money if you're still alive. They only get to receive it after you've passed away. But using a power of attorney, they can go and then access those funds, continue to manage the finances, pay bills, make sure that all the wheels keep turning. But if you already have this document, it is vital to ensure you have it done in the last 5 years. Banks are not accepting these unless they were done recently, and they have decided 5 years is recent enough. This is a reaction and a policy shift that came out of result of COVID. They were seeing increased cases of incapacity, and as a result, financial fraud and elder abuse cases increased. And so while it is not a law change, but a policy shift, it is one that causes nightmares if you have an out-of-date financial power of attorney. So make sure if you again have one, it has been done in the last 5 years. And if it hasn't been, take advantage of the time that we're able to provide, come and see us so that we can then update that for you. Now, one of the other huge issues with not having these documents in place is that you then need what is called a conservatorship if you are incapacitated. So what that means is you are at the stage where you can no longer again make your own medical or financial decisions, but you did not put in writing who has that authority. So unfortunately, that means the court gets to determine that. So that means we have to file for a conservatorship. We have to take whoever the person is asking to be the representative to court with us and essentially prove to the court that you are the right person to take care of your loved one. The court may approve it, they may not, but there is a lot that goes into a conservatorship that makes it a nightmare situation. And because the loved one is incapacitated, they are sitting there vulnerable without the proper protections that they could have had they simply put those 2 documents in place ahead of time. Conservatorships are time-consuming and they are expensive. It is heartbreaking when we're helping clients through conservatorships to hear how much they're having to go through both financially and emotionally while they wait for the court to grant them the authority that, again, just those 2 simple documents would have taken care of. But again, having them isn't enough. You need to make sure they are valid. So I want to reemphasize, healthcare directives need to have been done since 2004. Financial powers of attorney need to have been done in the last 5 years. If you have any questions on that, please come and see us. Now, the next question that we're looking to answer is, do you need a will or do you need a trust? Now, most of our clients need a trust for one reason or another. A trust is essentially there to set out what's going to happen when you pass away. What happens if you are no longer here to say who gets to manage and wrap everything up for you, and ultimately, where does your estate go? Really quickly, do you do these documents in office? So we do have a meeting with you to establish, is this what you need? And then we would have you, yes, come and sign the documents here. We don't outsource it. It is all done within the Copenbarger firm. Now for the trust, again, this is where you're pre-answering questions so that the court does not need to after you've passed away. This is so extremely important to make sure that you have done beforehand, because I cannot emphasize enough. Once you are gone, you do not want the court getting involved. When the court gets involved, the time-consuming component is frankly staggering. It's normally 2 to 5 years of court involvement after somebody passes, and it is extremely expensive. It also means that you're putting all of the control in the court's hands, versus your trust allows, again, you to dictate all of the terms ahead of time, so that even when you're gone, you still have the final say. But there's to it with a trust, and I want to focus more today on the tax component and the Secure Act. So within a trust, you can do advanced planning protections. You can go beyond just the basic, here's who I want it to go to. And you can actually set out terms that ensure you are at a minimum reducing unnecessary taxes, but in a lot of cases, eliminating them. Without proper planning, what we see are estates that go again through court or even outside of court, and they didn't maximize the protections that were available. And so the estate or the children end up paying additional taxes that could have been avoided. And that is where, again, we want to focus on the Secure Act today. Now, before we transition to that, I mentioned a couple moments ago that you should have a trust and a will. The reason for that is when we set up a trust, we instruct our clients that certain assets need to go into the name of that trust. Generally, that includes property, checking accounts, savings accounts, and non-retirement investment accounts. But we understand that things happen. Just because we're instructing you to do something doesn't mean life isn't going to get in the way, or that 20 years down the road, you're going to remember every single point that we told you in your signing. So what we have done is created what is called a pour over will. And this is essentially a safety net for those assets. What it means is if you pass away with a trust, but you have a checking account, for example, that was never placed into the trust name. You were the sole owner. There's no beneficiaries on it. It's not in the trust. You pass away and it has nowhere then to go. Ordinarily, that asset would have to go through a full probate. But using this pour over will, your representative is able to say, no, court, you do not get to have full control over this. You need to give the asset back to the trust. So that not only does it reduce having to go through that 2 to 5 year process for this asset, it also ensures that everything goes back to your trust. So your intent is actually the thing that is carried out. If you do not have a Copenbarger trust and you do not know if you have this document, we are more than happy to review that for you. If you have a Copenbarger trust, you have a pour over will. But if for some reason you can't find it, or it's something that you just need to verify, again, reach out to us and we're happy to go through that with you. Now, going back to the legacy component and protection. So one of the things that Copenbarger offers is what is called a protective lifetime trust for kids. What that means is instead of the money paying to your kids after you die outright, where it just adds to their estate and has no protections, you can actually add a wall of insulation around their inheritance. What that means is if they're the right person to manage their inheritance, they would still manage it. They can buy and sell within those assets. They can spend the money, but the money is housed within this protective lifetime trust. Those trusts protect the inheritance from divorce, lawsuits, creditors, bankruptcy, and the IRS. Essentially, again, no outside predator can then get into that money. It also means that for getting even divorce, if your child is married and the spouse outlives your child, rather than if that spouse remarried, the inheritance going to a new family, it ensures that it would transfer down to grandchildren or to surviving kids of yours. So it ensures that it stays in your family rather than going to someone or a place that you do not know or maybe wouldn't have approved of. But this ties into the Secure Act. One of the big things on retirement accounts is you do not change the title, the ownership of those accounts to the trust. Retirement will transfer by beneficiary. With proper planning and proper provision in your trust, you can have the beneficiary on those accounts be your revocable trust. And this is extremely useful if you have these lifetime protection trusts set up. That way, the retirement fund can also receive this protection. But again, it has to be done correctly. So this is not something to now run to your advisor and say you need to put the trust as the beneficiary. You need to come and talk to us first. Because if your estate plan does not allow that, there can be significant tax consequences if it is done incorrectly. So all of that is to say, ask us first, and then we'll let you know what steps you are able to or not able to take, and then you can go from there. Now, the other group of beneficiaries to talk about are special needs beneficiaries. These are, and specifically, these are people who have government assistance because of the special need that they have. One of the big things that we hear from parents who do have special needs beneficiaries is, I can't leave them an inheritance because it will disqualify them from receiving their inheritance or from their benefits. That is not correct. If, again, you have proper planning, you can set up a special trust that allows an inheritance to be used to supplement government benefits rather than replace. That way, if the benefits won't cover groceries, for example, the inheritance that is left could. And so again, with proper planning, you can make sure that whatever your assets are, that they are funneled into a protective trust to ensure that your child doesn't lose those necessary benefits, but also doesn't miss out on that inheritance that could frankly help them quite a bit. So now I keep mentioning the Secure Act. Let's really dive into what that is. So the Secure Act went into effect now back in 2020, and it was modified in 2022. This had drastic effects on how retirement accounts can be inherited. Prior to this rule, it essentially meant that a beneficiary, so specifically I'm going to talk about children, could inherit retirement accounts and essentially continue on their lifetime for whatever was left in those accounts. So they had the required minimum distributions. It was treated how it is for you. What has shifted, though, is now children only have 10 years to take out that the principal that is left behind. So whatever value you have left from the date you pass away, they have a 10-year clock running that says the child needs to withdraw their share within 10 years, or there is a significant penalty at the end. So that has caused a lot of shifts. That is why we are doing this with Lifestyle Financial, because not only does this impact your estate planning and certain provisions within your estate plan, this has also drastically changed how people are saving. My dad was somebody who his entire life, his entire career, he was told you need to put money into your IRA, put it into a tax or into a retirement account. But what that has now meant is, as his only child, if he were to pass away, there would be a sizable tax over that 10-year period that the government would be able to collect. Because I don't just have to take required minimum distributions, I have to take that each year, then plus any additional principal to make sure over those 10 years, the account ultimately hits zero. Well, if you're like my dad, he hates the idea of the government getting 1 penny more than they absolutely are legally entitled to. And so one of the things that he has done is started restructuring and re-looking at how can he make sure he has the right protection during his life, but also when he passes away, that money he worked so hard for and saved for so many years with doesn't just get depleted now back to the government. So again, this is where the two sides absolutely work in conjunction. Now for this, I'm giving a little intro into what Charles is going to talk about, but there have also been changes that you need to be aware of for yourselves during life. Required minimum distribution ages have shifted. How much you're able to put in has shifted and for how long. So it is important to, again, make sure when you have these accounts, you at least talk to an advisor at some point or another, because these changes are not widely known. Many clients do not realize how much has shifted for their retirement planning. So one of the big things to make sure, though, again, going back to the estate planning side of things, is if you have a protective lifetime trust already established in your documents, you need to come and see us if you have not seen us since 2020. The reason is that the retirement section in your trust needs to comply with the current law, especially if you do want your retirement accounts to funnel through your trust into those protections. Now, I know this is a lot of information, and right now it is relatively vague because it may or may not apply to every single person who is watching this. But that is where I keep emphasizing, if you have questions, we would much rather you come and ask and us tell you everything is fine, you are good to go, than you guess, wait, or take an action that can cause a huge taxable event later down the road. Let's see. One of the questions is, do you believe the IRS will rule on non-spousal beneficiary RMD this year? I frankly don't know. With the IRS, with most government entities, very bluntly, they may tell us that they're going to come out with a new rule, a new law, a new XYZ on a certain date. It is sarcastically shocking to me how often those dates get surpassed. So it is frankly hard to say if any further answers will then be done. I'm now going to turn it over to Charles so that he can speak more specifically on what you need to know outside of the estate planning realm. So Lifestyle Financial is a firm that we have been working with for decades. And the reason is that the founder of our firm, his wife is actually who started Lifestyle Financial. And so she has turned it over to Charles. and they have continued working with us very closely. And one of the biggest values is having professionals that are willing to talk to each other. When you have professionals in different realms who are unwilling to communicate, you are not being served to the best and fullest extent. So finding someone who understands estate planning, finding estate planners who understand what they can and cannot help you with from a financial standpoint is invaluable. So I'm now going to turn it over to him to give a little bit more about who they are.
Good morning, everybody. I'm Charles. It is an absolute delight to be with you today. Before we dive into the financial implications of the Secure Act 2.0, I just wanted to take a few moments to introduce Lifestyle Financial. Our company is committed to redefining the way you approach your financial future. At Lifestyle Financial, we understand that finances are more than just numbers on a piece of paper. They're the foundation on which you build your dreams, pursue your passions, and create the life you envision for yourself as well as your loved ones. And so with a focus on blending financial expertise and a holistic understanding of your unique lifestyle goals, Lifestyle Financial is here to help you, to help accompany you on every step of your journey towards financial freedom, security, and peace. So to echo what Victoria said before I jump into the Secure Act about the importance of keeping your financial documents up to date, I just wanted to visit this just for a few moments and talk about how critically important it is not only to have those legal documents up to date, but also ensure that on the financial side, having your beneficiaries up to date. There are a variety of life events that can occur: divorce, marriage, remarriage, mixed families, passing of loved family members. And all of these situations can have big implications on beneficiaries. And so you always want to make sure that you're keeping those up to date. You wouldn't want an ex-spouse to inherit something, or perhaps have a situation where we had a prospective client come to meet with us. And to make a long story short, a young family, they had cancer. So the wife passed away, and then the husband passed away. And so their parents thought they were going to just work on their retirement accounts. Well, the problem is the husband named the wife and the wife named the husband as the beneficiary. They never went any steps further beyond that. And so what ended up happening is they had to go into probate court because they weren't listed as beneficiaries. There were no surviving beneficiaries listed. And so this was a completely preventable thing. They unfortunately weren't a client because this is one of the things that we go over and review with them. But it was just one of those things that really stood out in my mind. And so you always want to make sure that the beneficiaries are staying up to date. And it's a simple thing, because more than a couple people I've met with just assume, well, if there's no beneficiary, it just goes to my parents, right? Well, no, it has to go through probate court, and then the court has to decide who is the rightful heir to those assets. And then the other thing I just wanted to touch on briefly regarding the RMD and inheriting retirement accounts, as Victoria said, in the past, for spouses and non-spouses, if you inherited a retirement account, you could stretch the payments, the RMD, over your lifetime, and you would treat the account as if it was your own. Now, that has not changed for spouses. So if a spouse inherits a retirement account from a spouse, then they can still treat it as their own and still take the distributions over their lifetime. But with non-spouses having to take, so a child, take payments over a 10-year period as ordinary income, that can really affect someone's tax bracket and the amount of money that the government's going to be taking. And so there are strategies and conversations to be had about how we can potentially minimize the amount of taxes that are paid. Now, everyone's situation is different, so I want to avoid getting into specifics, but I'm more than happy to have that conversation with you if that is something of interest. So now I'd like to jump into the Secure Act. So the spirit of the Secure Act basically was primarily focused on enhancing retirement security for Americans. It aimed to build on the original Secure Act that passed in 2019, which introduced several changes to retirement savings rules. Secure Act 2.0 further reforms to boost that and bolster that retirement savings. So bolster retirement savings, improve access to retirement plans, and address some of the shortfalls in retirement income for individuals. And so one of the first thing is increased RMD age. So when you have a retirement account that is pre-tax, at a certain age, the government's going to force you to start taking minimum payments. And so with the Secure Act, what we saw is that the age at which you were required to take payments was risen. So it used to be 70 and a half, then it became 72. As of last year, it is 73. And in 2033, it is going to be 75. And so this allows retirees more time to plan for tax efficient withdrawal strategies. It allows more time to not only delay that tax burden, but also allow the retirement account to accumulate more. And so it's also the government wanting us to work longer. So they want you to work longer, they want more tax income. So it's not just about the government wanting us to have a comfortable retirement. Enhanced catch-up contributions. And so this provision targets older workers between 61 and 63, providing that an opportunity to significantly increase your retirement savings. So you can put in significantly greater catch-up contributions to your retirement, because one of the things with retirement planning is that the way compounding interest works, the longer you have money to work and compound every year, the more your retirement plan is going to grow. But unfortunately, as we progress in our careers, we earn more money later in life than we do in the beginning of our careers. And so that presents us with a conundrum. But with the enhanced catch-up contribution, we can now add more money into these accounts and allow us to really funnel as much as possible into our retirement accounts. Automatic enrollment in retirement plans. So this feature is set to increase participation rates and overall retirement savings. So gone are the days where employees would have to approach an employer about signing up for a 401k after the blackout period. So some employers have a 3-month, 6-month window where you have to be on probation essentially. And then after that, you qualify to start contributing to the 401k. Well, now there's an automatic enrollment feature where the employer is now required to automatically put you in. This is encouraging employees to not only stay in the plan and get enrolled in the plan, because we have busy lives and retirement plan savings, 401ks are generally not on the top of anyone's to-do list or on the top of our minds. Matching contributions for student loan payments. So many workers had to decide whether they were going to put into the retirement account or make student loan payments. And so this innovative feature of the Secure Act allows employers to match payments that workers are making to their student loan payments, but put money into their retirement. So it will allow for more savings, and it prevents employees from having to decide whether they're going to be paying down student debt or starting to contribute to their retirement. And it also assists employers in structuring their benefits to include this option, making the job more attractive to younger employees burdened with student debt. As someone who has 4 kids, 2 who are about to enter college, I can tell you that student debt is a real thing and educational costs are quite high. Which brings me to 529 accounts. So college savings accounts. 529 plans allow us to put post-tax money, so money that's already been taxed, into a investment account that will grow tax-free and will not be taxed, provided it is used for higher education expenses. Now, One of the problems is that as soon as money goes into a college savings account or a 529, if you take it out for any purpose other than higher education, you're penalized 10% and then taxed on all the earnings. And so that essentially made the money a little bit stuck because you could only use it for education. Now, you can always change the beneficiary. So if it was for a child, you could redirect those funds to a grandchild or a niece or a nephew, as long as it was used for higher education. But what the Secure Act 2.0 allows you to do is it allows these 529 accounts to be rolled over into a Roth IRA. Now, there are a few caveats, one being that the money must have been in there for at least 15 years, and there's a limit of 35,000. But this is a huge benefit because there are a lot of assets sitting in 529s where the owners of the account are not quite sure what to do with the money, faced with not having a need and not wanting to pay taxes and face a penalty. There are also some enhancements for small business retirement plans. So increased tax credits and simplified safe harbor rules. And so what safe harbor refers to is basically it's the non-discriminatory test. And so in order to prevent employers from essentially just rewarding having a what they call top heavy plan, where executives, people who are high income earners, highly compensated employees from just putting tons of money into their retirement account, and then other workers who do not have as much disposable income being unable to really participate to much of an extent. That's a little bit, they call it prejudice on the plan. And so in order to get around that, there's something called safe harbor. What a safe harbor plan essentially does is it has a minimum contribution on the employer side for all employees. So sometimes that's 3%, 4%, but what the Secure Act did is that it simplified this a lot. Whereas before there would have to be annual tests, and it just created a big burden on the employer side. And so now it simplifies a lot of that process. And so it also makes it a lot more attractive for employers. So now there's just more offerings for employees. With people changing jobs, one of the problems is as we get busy, many times you have a small, perhaps, retirement account somewhere, and then you didn't get statements on it. Long story short, people forgot about these retirement accounts as they change jobs. And I like to call them orphans. So retirement account orphans or orphan 401ks. And this became a problem because people couldn't find where their retirement accounts were. And what the Secure Act did was it created a national lost and found database for retirement accounts. And so this is going to be one place that can help assist clients in using a database to locate any lost retirement accounts. And that can be helpful because as you leave places of employment, you can roll those 401ks over. And when you retire, you have the option of rolling these into an IRA and consolidating and making things a little bit easier. I met with someone 2 weeks ago who had 10 different 401k accounts. As you can imagine, that would be rather difficult to manage. And so consolidation makes a lot of sense. And the last thing that I wanted to cover was the emergency savings account. So this provision allows certain employers to offer an emergency fund where employees can contribute in their own account pre-tax and then pull out if they needed to without any penalties. And so this is really helpful because things can happen in life and they're often unexpected. And so all these provisions in the Secure Act are designed to further really increase the robustness and the resiliency of retirement, especially as we see things like Social Security, pensions going away. Social Security is just simply not able to provide a retirement. And as we see higher inflation coming in, retirement is getting more expensive. And so this was designed to help people get stronger and stronger retirements. And with all that being said, if something I talked about today sparked your interest or you're just starting your financial planning journey, regardless of where you are, if you'd like to set up an appointment with us, I'm more than happy to set aside some time and meet with you. So thank you.
Perfect. Thank you as well. All right, so this was a decent amount focused on a fairly complex topic. And so if you do have questions, please feel free to reach out. As the last couple slides, there we are, had shown, it is a free consultation with Lifestyle. For Copenbarger, you are also entitled to a free consultation if you have not met with us this year already. So if you have questions, please let us know. One of the things that we can also do at Copenbarger is review your current plan, make sure that there's nothing else that has shifted or needs to be updated in conjunction with the Secure Act specifically. Now, if you are new to Copenbarger and you are wondering, okay, of all the estate planning firms, why should we choose yours? There's a couple of things that very much set us apart. One of those is the fact that we do these education events. The education events, the webinars, seminars, online recordings, blogs even that we provide, allow people to have access to the education side of it, which means rather than you having to go and try to keep track of what laws are changing, figure out how they apply to you, and then decide if you need to contact us, we are able to contact you. So what that means is we are staying up to date on the laws. We are looking at how do these affect our clients in one way, shape, or form. And then we present the material so that you can then decide, is this something that sparked more interest, more questions, more necessity? The other thing is that we have been around since 1979. And within that, going back to education, our attorneys have also continued to educate themselves. We continually throughout the year are keeping track of what are the different laws that are changing and how may they or may they not, again, impact our clients. So these are things that we do that go above and beyond just establishing documents or doing a superficial look at what you need. I'm going to answer a couple of questions here at the very end. So after this, you will receive an automated phone call asking if you would like us to schedule an appointment for you. If you also would like to contact Lifestyle Financial, you can use that automated phone call for us to get you their information as well. I'm going to ask my team if they're able to, on this call, to put Lifestyle's information in that chat for you. The other thing to keep an eye on is in that chat, we just sent you a link for a short survey to let us know how we did. One of the things with these education events is we want to make sure that they're helpful for you. And if there's any way that we can improve, we want to make sure that we are doing so. Now, one of the questions I did just have is, can you bring a current trust that was done by someone else? Yes, we can absolutely take a look at that trust and then see what needs to be updated, if anything. Another question is, if you have a trust from 2002, kids are now grown, should you bring it in? Are there changes? Yes, please bring it in. If you have not done anything since 2002, very likely there are going to be different changes that are needed. So thank you again for spending some time with us today. We very much appreciate you taking that time out to learn more about the Secure Act and how each of our different teams can support you. We are looking forward to working with you either for the first time or continuing that relationship with you and your family. I'm going to stick around for a little bit to answer any other questions that may come in. Again, please let us know in that survey how we have done, and you can find Lifestyle Financial's information in the chat. Thank you, David. All right, we hope everybody else has a great day, and we again look forward to working with you.